is, which he supplied to you, did not address the criminal malfeasance act of the city clerk, which is what this issue is about. And therefore, that doesn't even apply. Res judicata cannot apply for the facts dealing with the city clerk was never addressed on their merits. And the issue of criminal official malfeasance was never addressed, nor is it in the petition or in the case itself. But the 7 other petitioners make res judicata moot because they were not parties to that particular lawsuit. And I think I cited state law, state case law in a letter that I submitted to Ms. Anderson Davis a while ago, which sets forth why res judicata is moot. Collateral estoppel, of course, doesn't apply.
Madam Chair, may I request the board?
Yes, sir. Please identify yourself.
Yes, John Pirich on behalf of Michael Duggan from the Mayor Committee. At last Saturday's meeting, after I provided information to the board regarding the lawsuit as well as the judgment, Mr. Board Member Zura asked that we provide the complaint, which I provided. If you look at the complaint filed by Mr. Darrow and others against the City of Detroit Election Commission, Janice Winfrey, City Clerk for the City of Detroit, Mr. Duggan, and Michael Duggan from the Mayor Committee. If you go to count 1, which is on page 9 of the 20-page complaint, it sought a declaratory judgment that the defendant Duggan and defendant Duggan from Mayor Committee did not have the legal authority to print, distribute, and or circulate instructional ballots, quote, unquote, to the voters of the City of Detroit. This count specifically focuses on that entire allegation with regard to, first, whether or not Mr. Duggan can be a writing candidate, which, of course, the court ruled that anyone can be a writing candidate and have the standards, but filled out the declaration, which Mr. Duggan did. And then if you go through the complaint, paragraph 37, the allegation about the printing, distribution, and circulating the instructional ballots, he said was a violation of law. He cited in paragraph 38, section 718 of the election code, which I referred to last Saturday. In paragraph 39, he suggested again that the printing or distribution or circulating of instruction ballots was in violation of MCL 168.718. In addition, he said that the website was illegal. And in paragraph 40, he attached both the literature and made the allegation again that this was unlawfully printed, distributed, or circulated to the electors. And he also included Exhibit J, an instructional ballot. In paragraph 41, he made the same allegations that Exhibits I and J violated Section 718. And he had a litany of the allegations contained below in that subsection. In Section 42, he said that Section 718 stated that candidates named on official ballots could only legally or procure or circulate instructional ballots if they complied with that section. All of those were fully litigated against Mr. Duggan, the committee, the City of Detroit Elections Commission, and Janet Winfrey in her official capacity as the city clerk for the City of Detroit. And if you look at the order, it quite specifically says the court, having heard the emergency motion, which by the way was not an emergency, but in spite of that, the briefs and the arguments, and it said after due consideration of the party's position, the court being fully advised in the premises, therefore ordered that, number 1, plaintiff's motion, that was Mr. Barrow's motion, was denied for the reasons stated on the record, and number 2, defendant Duggan and Duggan for Mayor, motion for summary disposition is granted pursuant to MCR 2.116C10 for the reasons stated on the record. And it continues, defendant, City of Detroit Elections Commission, and Janet Winfrey were also granted the same motion. So Mr. Barrow can say, well, there are other people, but this is the same allegation. And the allegation was litigated. The court clearly ruled that the use of the instructional ballots was absolutely permissible and committed under Section 718 of the Election Code. So this is just an ongoing attempt to make these allegations and to make these complaints, when in fact, clearly it's been litigated, decided, and Mr. Barrow even said last Saturday that he did not appeal that decision. It had nothing to do with the case after that. So we respectfully request that you deny the request that is sought in this particular regard.
Thank you.
Thank you very much.
May I address the board? I believe we need to... May I address the board? No, ma'am.
Well, she's a party to it. She's a party.
I am a party to this action, and I was not a party to this lawsuit that's being referenced. I haven't seen any of the pleadings. I didn't sign off on any of the pleadings, but I do have fraud allegations against this clerk, and I want them heard. I do not want them summarily dismissed. Please, if everyone would please turn off their phone ringers at this time, we'd appreciate it.
Mr. Wilcoxon does have a petition for a recount that this board approved, which is an allegation.
Cites that specific matter.
The specific matter is cited in...
But as importantly, Madam Chair, in that particular thing that Mr. Pirich referenced, there's no allegation of criminal malfeasance against the city clerk. This is new. And because it's new facts, it's never been directly addressed on its merits under the case law. He's not citing case law. I've cited case law that makes what the conditions are for res judicata. And I submitted that to this board. So this board needs to be made aware of that and why it does not apply. He doesn't address it. The parties are different. The facts are different. And it's never been directly addressed in the merit. And we don't have the record from the lower court. Just his representation. That's all. And the reading of an order.
May I now address the board? Yes, please. Okay. I was not a party to this lawsuit that's being discussed here. I have never seen a pleading. I have not signed any affidavits relative to the allegations that were pled in that case. I have a lawsuit that was filed against, I have a petition that was filed with this board alleging fraud on the part of City Clerk Janice M. Winfrey. Has nothing to do with Mr. Duggan. I haven't sued Mr. Duggan, have no allegations or even qualms with Mr. Duggan. I do have problems with our city clerk. We do not know how many ballots were printed. We don't know how many were used. We have allegations relative to affidavits where people are saying that ballots were pre-printed in direct contradiction to Judge Popke's decision, which was no ballots are to be printed with Mr. Duggan's name on it. That's a court order. If those ballots are in fact found, that means that there's been contempt of court. So I am asking that this board do its job and investigate to the fullest extent of the law. And in order to do that, I would suggest that the case be turned over to the Wayne County prosecutor who has the staff and the capacity to investigate these issues. This board cannot summarily decide that it's not going to investigate. That is our job to determine whether or not to investigate if there has been proper evidence supplied to us. Okay, is there any discussion from the board on this now?
If I may
Yes,
address
Ms. Anderson,
the board,
yes.
I would like to advise the board that I have been in communication with the Detroit City Law Department, and I did ask them to supply an affidavit or a statement from Janice Winfrey concerning the allegations in the petition. I was promised such a statement, but it has not arrived.
I didn't hear you.
I said that I had been in constant communication with the city law department, and I had asked them to have the city clerk, Janice Winfrey, to supply a statement or an affidavit regarding the allegations in the recount petition. I was promised such a statement, but it has not arrived.
Is there an expectation as to when it might be received at all?
I asked that it arrive before today's meeting.
Okay.
I'm sure you have precinct 251 here. You can look at the ballot and see if it is a mimic, an exact duplicate, an exact identical picture of the ballot that they have. There's no problem with instructional materials. This is not an instructional material. This is an identical ballot to the real one, complete with name rotation. And I share that in a letter with the Corporation Council. And you have that case here to see, to get to the bottom of it. If it's not, then it's moot. If it is, then there's a problem of criminal malfeasance.
Okay, yes, Mr. Barrow, this particular letter has been forwarded by you to Kim Worthy, who is the Wayne County prosecutor, Ruth Johnson, who's the Michigan State Secretary of State,
Robert Schuette, Michigan Attorney General, and Barbara McQuaid, the U.S. Attorney. We have not been contacted by any of them.
That letter is dated today. I think that's dated like 40 an hour ago. So they certainly would not
But this
have
issue has gone to them before, has it not?
It has not. And in this is going to be the first time that this board has to deal with they got a copy of our recount petition, yes, but that's all they got. But this board has a duty to investigate and get to the bottom of this as to whether there may not be a crime. If in fact it turns out that it was not an official ballot, with exactly the same font, exactly the same layout and all.
Okay.
But we know it was
I
a crime.
personally am satisfied with Judge Poppy's.
Absolutely.
What about the other parties who weren't a part of the lawsuit? Where's res judicata?
What's the pleasure of this board?
You're a lawyer, Ms. Richmond. It's not res judicata. You're a lawyer. You're an officer of the court. You're an officer of the court.
Counsel, do you have any comment?
I have no comment.
I just gave you something related to the project.
You're officers of the court. You know the privies.
I was also not a part of that lawsuit.
Mr. Board.
Recount.
I wasn't.
Oh, that's right. See?
Madam Chair.
And I
Should be
have been
speaking
here
so
all
that the
day.
public can hear.
Madam Chair.
Yeah.
I was counsel for Mike Duggan in the hearing. I was there in the courtroom, and co-counsel Pirich and I argued the case in front of Judge Poppy. The allegation from Mr. Barrow's lawyer, Drew Patterson, was that the ballot was improperly gained and that it was somehow used improperly. The judge looked at that issue. It was fully vetted and fully argued on both sides. So there was counsel for the city of Detroit, there was counsel for the Duggan campaign, there was counsel for the Barrow campaign, and the judge considered all of those matters fully and fairly, and looked at all of the allegations and determined that the key thing in this, the key determination, is can something be voted on? That's really the issue as to whether there is an improper ballot. It's can this thing be submitted as a vote? And the judge said, no, it's clearly meant for educational materials, dealt with it, ruled denied. Denied. So the contempt issue would be is to try to open up something that a circuit judge has already ruled on and that has not been taken up on appeal. This issue is fully and fairly and faithfully behind and resolved, and so I would ask this board to move that this request for a reopening of what has already been litigated be denied.
Madam Chair,
I think we've heard from everyone at
May
this
I
time.
ask the board?
he has no record. He's simply saying
Okay,
he has no record.
Mr. Barrow and Ms. Wilcoxon, I believe we've heard from everyone. This is the fourth time that we have actually...
No, you have
sat
not
at the
heard
table.
from me relative to Judge Poppy's decision and how it relates.
You were not a party to that case.
Well,
I'm
that's
sorry.
exactly why you
That's
can't
the
do
point.
it.
I was not.
Thank you. Well, that's the point we needed. Thank you. Again, what's your
Is it
board?
res judicata, Ms. Hartoon?
Mr. Barrow, this
Please
is not
stop
a court
trying to
of law.
intimidate
This
the
is
board,
not
Mr.
a
Barrow.
court of law. And your insistence on trying to call me out
And
as
Mr.
if it
Barrow,
is.
You are a
You
lawyer,
are not
Ms.
an
Hartoon.
attorney, are you? Well,
Res
Mr. Barrow, are you an
judicata
attorney?
and the
to
case
confirm
law is
this
clear.
allegation?
And he doesn't have a transcript. He simply makes a self-serving statement. He doesn't have
Okay,
that.
does the board wish to take any action on this particular issue at this
Yeah.
time?
Yeah.
We are talking about project
wrong.
where we
It's
will
wrong.
complete our entire process and investigation at this point. I don't know that anything's going to change on
Can we
this
use our public
particular
comment
issue.
right now instead of later in public comment?
Okay,
It is just...
Since you won't allow...
Is there a motion regarding,
candidates this week until the public...
probable
We can
cause?
switch our time and use it now instead of later.
excuse me, you have not been recognized. Is there a motion at this time?
Madam Chair,
Is there a motion from either of the board members at this time?